I think the health care law, if it gets to the Supreme Court this term, and I no longer think that's a certainty, but I think if it gets to the Supreme Court this term,
Flesh out a little bit why you think it's no longer a certainty.
well, I think the jurisdictional issues are significant. The question of whether the Tax Injunction Act prohibits the challenge to a federal tax until you've actually paid the tax, which would be April of 2015 when the first person has to pay $95 for not having coverage. Whether that should lead to the postponement of the litigation, they're standing issues. The Sixth Circuit plaintiffs said that their case is ripe because they need to start saving money now because they have so little money. But the healthcare law has a provision excusing anyone for whom it would be a financial hardship. So they've almost pled their way out of having a real case or controversy in the Sixth Circuit case. So I think there are some problems. I've always thought at the end of the day it was going to be upheld. It wasn't going to be close. It wasn't going to come down to Justice Kennedy. I rarely make predictions, unlike Tom, but I thought it. I know, and you had mentioned that he does make predictions. I've always thought it'd be at least 7-2 to uphold it, maybe 8-1, and Justice Thomas, because he is willing to reconsider very well settled precedents from both the 19th and 20th centuries in a variety of areas. No, he has made that explicitly clear. I would assume the Chief Justice would assign the opinion to himself and would not want to write an opinion that said that the only way to deal with major social problems is for Congress to have a single-payer government-run program rather than to have incentives to participate in the private market. And I think that the notion of whether this is within the jurisdictional box of commerce is an almost ridiculously easy question. That is, it's incentives to make a purchase in interstate commerce. They're not raising any liberty issues in this case. It's in that subject matter box, just as, and the arguments that there are a lot of other things Congress might do with that jurisdiction are arguments that don't actually work when the only question is whether something is within a subject matter. So, for example, I think as you and I have discussed, the attack on the Social Security law said that if Congress has the power to do this, they can set the Social Security age at 25. Well, yes, that's because it's a jurisdictional question. When the minimum wage law was passed, the question whether that fit within commerce among the states, the statement was made if Congress can pass a minimum wage of $5 an hour, it can pass a minimum wage of $5,000 an hour. Well, of course, but that's the nature of jurisdiction. There are other constitutional doctrines that come into play when Congress does such a thing. And right now, it is indisputably within the commerce power for Congress to enact all kinds of ridiculous regulations when you engage in commerce. So that, and I think Judge Sutton's opinion makes a huge difference by identifying the fact that that the notion that this is a regulation of inactivity makes no sense. This is a healthcare service is something no one can be sure they won't be using. When they do need them, they will be provided for them, at least in some fashion. The costs will be transferred to others if you're going to self-insure. He said that is a very active process of self-insurance, a very active process. And therefore, I think you put all that together, this is not, I think this is not going to be seen as a difficult case. Miguel thinks otherwise.
Well, actually, I think it's a very complicated issue at a number of levels. Dealing with the first issue that Neil identified as to when, if ever, it will get to the Supreme Court, I think we should all agree that it would be in the public interest for the adjudication of the issue, which contentious as it is, to have it done with and to get it on its way to the Supreme Court just as soon as we can. It's a clean legal issue. You don't need to have any sort of factual issues on that. And you know, we've had rulings from multiple courts on all sides of the issue. It is nonetheless very clear that the strategy of the administration is to do cartwheels to keep the case out of the Supreme Court so as not to have a ruling before the 2012 election. I mean, they take every extension, they do everything they can to stretch it out, and just so that you know, if a case on this issue is not taken by basically the second week in January 2012, you will not have a ruling before the election because it will not be heard unless they have a a special sitting. And I will bet you any amount of money that the administration is going to seek en banc in the 11th Circuit. Even if you look at the composition of the panel, there is no way in heck they would get it, but they want to chew up, the time just to make sure that if and when the court gets it, it is not for a ruling until after the election. Now, once you do get it there, the issues are really hard. Every time you ask the Supreme Court to overturn an act of Congress, it's a very difficult thing for the court to do. And Congress comes to the Supreme Court with a presumption of deference and constitutionality. There are issues as to the standing and as to the jurisdiction. If this were, in fact, a tax, I think you may be right that there is a jurisdictional question. The case of the administration on the tax issue is not aided by the fact that the man who signed the bill, the President of the United States, went on the speaking circuit saying that it wasn't a tax. And he was challenged on TV with somebody with a dictionary saying, this is the definition of a tax. And he said, I don't care what you call it, it is not a tax. And at some point, there is a question as to whether, if you're dealing with user fees or burdens or impositions that could reasonably be called a tax, whether you are not owed some level of deference to the guy who signed the thing and take him at his word. The commerce issue is actually very hard because you have the Wicker versus Filburn case and you have the Rage case. I have a lot of respect for Jeff Sutton, and I think his analysis was a very honest attempt to grapple with a difficult question. I also have a lot of respect for Frank Hall on the 11th Circuit, who was a Clinton appointee to that court, and she labored equally hard to grapple with that question, and they came to very different conclusions. It's a hard question.
What about the Fourth Circuit? Do you have respect for their opinion as well?
Well, no, I do, but they were the court that said the Tax Injunction Act would apply, and I think that is a plausible argument if you accept the proposition that you ought not to take the President of the United States at his word.
You're totally wrong on that, because whether or not the Tax Injunction Act bars this has nothing to do with whether you can constitutionally defend it as an exercise of the taxing power. That is, it's quite clear that if there's a surcharge of 2.5% on the federal income tax, that is a tax within the meaning of the Tax Injunction Act. You might say, we're not going to uphold this as an exercise of the power because of the signaling function, but that doesn't change the fact of that.